Hi, welcome to lecture number 2 in our continuing series of lectures on common law contracts. Today we're going to go over some very important terms that are necessary to understand the law of contracts, the law of common law contracts. Remember, we're still talking about common law, not UCC, which we'll talk about in a couple of weeks. Anyway, what I want you to do is turn to page 282 in your text. And at the top of the page, there is a list of terms and concepts. And I'm going to indicate those terms and concepts that I want you particularly to pay attention to. And then I'm going to talk about several of those. I'm just going to list these: bilateral mistake, breach of contract, commercial impracticality, consequential damages, discharge in bankruptcy, impossibility of performance, incidental damages, liquidated damages, mitigation of damages, mutual rescission, nominal damages, specific performance, and unilateral mistake. And we're going to talk about some of those in the next several lectures. But today, what I want to talk about is a couple of terms. One, I want to talk to you about mistakes. There are two kinds of mistakes: mistakes of fact and mistakes of value. Mistakes of fact are the mistakes that a party or both parties in a contract make concerning a fact, but it must be a material fact. And what's a material fact? Material fact is something that's important, not something that's minor, not something that can be overlooked easily. The judge or the jury must decide what a material fact is, but usually you can make up your own mind what a material fact is. Now, there's two kinds of mistakes of fact. One is unilateral, and that is that only one party makes the mistake. The second is bilateral. That is, both parties make the same mistake of fact. Now keep in mind that if it's a unilateral mistake of fact, there's no relief in the contract. That the contract must be performed by both parties, even if one party makes a mistake of fact. But in a bilateral contract, a bilateral mistake, then there's often relief. That is, when both parties make the same mistake in fact, the court will often grant relief. Now, the second kind of mistake is a mistake of value. Mistakes of value, even if made by both parties, are usually enforceable in the contract. Why? Even though both parties make the same mistake, it is because value is variable. My desire for this particular thing is different than your desire. Remember our discussion about consideration. In consideration, a court will never determine whether or not consideration is worth the contract, because it does not know whether or not you value that consideration, how much. So remember, a mistake in value is normally enforceable in a contract. For example, if you go to a garage sale and pick up a used violin that you think is old, then and the garage seller wants $25 for that violin, and you say you buy it for $25, but later find out that it's a 14th century Stradivarius. I don't know what Stradivarius were built in the 14th century or not, but that's an example. And it's worth $250,000. That contract will be enforceable, and the seller of the contract will not be able to get it back. The next thing we're going to talk about, the next two terms are very difficult because it's impossibility to perform a contract and impracticality to perform a contract. Impossible means that it is objectively not possible to perform the contract. For example, I'm getting ready to sell you my 1994 Ford Ranger pickup truck. The day before the sale, after we've already agreed to sell in that price, the pickup truck is struck by lightning and burns up. Well, it's impossible to sell because it no longer exists. So it's objectively impossible. And you can get out of a contract because of impossibility. But the more difficult concept is impracticality. Impracticality is when the contract becomes more difficult or more expensive to perform. And I don't mean just a little bit. I mean a lot more expensive or a lot more difficult. And impracticality is often agreed to by the courts to allow a party not to perform their contract. How much more difficult and how much more expensive? Well, that's a good question, and the judge and the jury decide that. But a couple of old California cases said that 10 to 12 times more expensive was commercially impractical. And another old California case said that twice as expensive is not impractical. I don't suggest you use this as a reason to get out of your contract because you just never hope how it's going to fall. But commercial impracticality is a way to get out of the contract and be relieved of one party's burden to perform that contract. Now, you notice that there are a number of different concepts of damages in the list that I read you. We're going to talk about damages in a later lecture, so we'll leave that for another time. So we'll see you next time for another lecture.